Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, and today I'm joined by my very favorite guest, David Adler of the Adler Law Group. And today we're going to be talking about how do you choose the right name for your practice, whether it's a medical practice, a dental practice, or any other business that you're wanting to start. How do you choose the right name? Dave is going to talk to us about some of the considerations that you should make when choosing that name, how to protect it if you're spending a lot of time and money on branding, and some other considerations. So welcome. Thanks for joining me.
Yeah, hi. Thanks for having me. Always a pleasure to be on the Health Law Hotspot.
All right. So Dave and I work together a lot with clients of mine that are starting a new practice. And often they'll tell me, the entity that they want to form and the name they want to use. And I am certainly not an authority on trademark law, but I'm always concerned, especially when they're starting a new practice, they're going to be branding and investing in that name, about whether or not they've chosen a name that somebody could eventually prevent them from using. And so that's what leads me to have them talk with somebody like Dave that can kind of give them a little bit of insight. So why don't we start with you kind of explaining, when somebody chooses a name, what are some of the things that they should be thinking about?
Yeah, I think that's a great question. And, I think people are always looking for names that are easy to remember, kind of tell people a little bit about what you do so that they can connect those dots and think of you when they're thinking of that particular good or service. The trick is to find something that is distinctive or unique. And what I see a lot and very often is, especially amongst doctors, dentists, other professionals, is they tend to choose names that are very descriptive of what they do. So, for example, there will also, often be, if they're in a particular specialty, it might be like cardiac associates, right? Which is, it tells you a little bit about what they do, but of course, cardiac would be, generic or descriptive for something like medical services. So the first thing to think about really is, what's a good name? What's a strong name? What's a name that's going to be memorable to my patients or other customers, right? And so that's kind of the first thing to just start thinking about.
Okay. And I guess, some other things that I see are people that describe more like their location. So Midwest, North Shore, Midtown, those kinds of things, which are very, very common. In fact, we have clients that have chosen almost identically the same name, right? And so when you're choosing a name, you want people to kind of know what you do. I guess I understand the inclination for that. But what can happen if you choose a name that is very similar to someone else? And I just want to point out that, in every state, when you register a name, if somebody else has a name that's the same, you're not going to be able to get it. But that doesn't mean there isn't somebody with the exact same name in another state. And that doesn't mean that there isn't somebody with a trademark for that same name. So what do people need to do to make sure that the name they choose is one that won't be taken away from them?
Yeah, I think that's another good question. I think you raised a lot of good issues, important issues there. The first thing you need to do is, if it's a name that you haven't already been using, right? So if it's a new name, you're going to change your business, you're starting a new business, you want to do what's known as a clearance search or a knockout search. Sometimes you can do this by yourself. Sometimes you can hire a third party to do it. Often the best route is to work with a trademark lawyer who kind of knows the ins and outs of these types of searches. And really the idea is to make sure that the word or the phrase or the logo or whatever your trademark is, that nobody else is using either the exact same name, right, or anything that would be considered similar. Because there's a couple of principles in trademark law, one of which is first in time is first in right. So the first business to start using a particular trademark is really the first person or first business to have rights in that name. Now, you mentioned things like you've got clients who are all over the state and they probably use Illinois in their name, Midwest, North Shore, right? So it's very possible that you might have people with similar names in very different geographies, right? And that's why, again, it's kind of important to do that clearance search to see, okay, maybe there's nobody in my backyard, maybe there's nobody in my state, but maybe if I go one state over, there's somebody using the same name. So, a thorough trademark clearance search will give you a good idea about whether or not anybody else is using your name and whether you can keep moving forward with it.
Right. And I know even when people try and be very clever and come up with a unique name, I will just kind of Google myself. And often there's companies across the country that are using a similar name or using that a particular word, with other words associated with it. So even if it's not like a descriptive of the specialty or the area geography that they're in, oftentimes people think they're being clever and they choose a word, but they're not the first one to think about it. So what happens if you start a new practice? You've chosen a name that nobody else in Illinois is using. You think it's great. You start branding. You're out on social media. You got your business cards, whatever, and suddenly you get a letter saying, "Hey, wait a second. We started using this name before you. We don't want you using it anymore." So, does that happen, and is there any defense to that?
Right. That's another great question. Unfortunately, it happens more often than you might think. It tends to happen amongst small businesses who, for whatever reason, may have not invested in doing a trademark clearance or something along those lines. Every situation is unique. So you have to look at, what name are you using? What name is this other party using? Or how similar are they? Are you offering the same goods and services? Typically, if you're on the receiving end of a cease and desist letter or a nastygram, as we sometimes call them, chances are you're using a very similar name and you're probably in the same space. So we see it a lot with med spas. We see it a lot with other aesthetics businesses because they seem to be proliferating. We see it a lot with, even just private medical practices because of the tendency to use these names that are somewhat common in the industry, right? And can kind of lend themselves to these problems where, you run up against somebody else who claims to be using the name first.
Right. So, like the word, if you're a dentist, the word smile, teeth, right?
Right,
White.
right.
So, what happens though if you've been using a name for quite a long time, but somebody else has actually filed a trademark with that name and they send you a letter saying, "Hey, you got to stop using this name. We've got a trademark." What happens then?
Right. Well, that's also a very complicated sort of facts and circumstances type analysis. You remember I said first in time is first in right. So even if you haven't gone through the formality of registering your trademark at the state level or registering it at the federal level, but you've been using it and you've been marketing it and you've been using it for a substantial period of time, you have rights in that trademark. Now, if somebody comes along later and they're good faith adopts the same mark or a similar mark without any knowledge of your use, they may be able to keep their mark, within the scope of their alleged use or the use that they can prove. For you even though you're the senior user, depending on the scope of the rights that you establish, you might be limited to the city that you're located in or the state that you're in, and you may not be able to grow beyond that. That's not to say that the later user can force you to change your name, right? I mean, it really kind of depends on how hard you want to go to the mat. I have seen people, fight that fight. It really depends on how invested in the name you are. And, in this day and age, okay, with social media, with everybody being online, I think it's more likely that there will be the the ability to see other brands and sort of that awareness, that notice of other people is I think more likely. And certainly it's been my experience that in certain cases, if we look hard enough, we can kind of see evidence that the junior user was aware of the senior user at the time they adopted the mark. And that's a great situation. Like if you can show something like that, that's great. Unfortunately, a lot of times small businesses, they use a name, they don't necessarily keep great records. Maybe they do some advertising here. Maybe one year they do a little, they do a little Google AdWords, and maybe the next year they run a Yellow Pages ad or something like that. So they haven't really done a lot of that investing in the branding. That can make it hard to prove the strength of your mark. Another thing that sort of comes out of your hypothetical or your question is kind of the concept of the strength of the mark, right? You mentioned using words that are sort of common in the industry, like smile for dentist, right? So trademarks kind of run on what we call a continuum. At one end are generic words, which are, coffee for coffee, dentist for dentist, things like that. On the other end of the spectrum are distinctive or made up or what we call fanciful words like Kleenex or Google, words that didn't exist before. And then, somewhere in the middle, we have what are known as descriptive words or suggestive words. And all trademarks kind of run along this continuum. When you have trademarks, whether they're words or phrases that are at the generic end of the spectrum, they're very hard to protect, really, because they stand for what they are, and there's really no source identifying function to it. However, generic words and descriptive words or phrases can become distinctive over time. And there's a lot to that, proving sort of this acquired distinctiveness. It's, obviously like everything else in trademark law, a multi-factor test, but there are ways to sort of establish your trademark. At the distinctive end of the spectrum, so words that are made up, words that are fanciful, words that are highly suggestive or arbitrary, those words are more protectable. So when you hear the word Apple, everybody thinks of a consumer electronics company or a computer company or their iPhone or whatever. People do not think of fruit, right? So that would be considered an arbitrary mark. I did a little search just in preparation for our podcast to see to give listeners an idea of what trademarks have been applied for at the federal level that haven't that have been denied because they just don't meet protectable level of distinction. And so one I came across was a mark. Somebody tried to register the phrase cranial/structural for educational services in the field of medical massage and medical massage therapy. Right? Obviously, cranial and structural are very descriptive of the area where the services are provided. And there's really nothing, special or distinctive about these words. So they're generic for what they are. So the trademark office says these words can't be protected as a trademark. Another word that I looked up, I tried to find some trademarks that involved concierge medicine because I know that is very popular. And certainly with concierge medicine, I think you have a heightened need to really, have good branding, good solid trademarks and trade names because you're really marketing to a different consumer segment. So in this case, a company called Angel Medical Systems, Inc. tried to register cardiac concierge for medical services, and that was a mere descriptiveness refusal. The trademark office said that cardiac concierge was descriptive of the services that a consumer would expect to receive from that mark. So that's at kind of the weak end of the spectrum. And those the reason I bring those up is because those tend to be sort of those familiar words and phrases that people like to use. So when you're thinking of branding your company, when you're thinking about choosing a name, you can start with these and then try and think, okay, well, how do I make it more distinctive? How do I really punch it up a bit so that it's not going to sound like every other name that's out there in the marketplace? And sometimes that might be adding some interesting characters to it, spelling it differently, maybe thinking of using synonyms for certain words, right, to kind of get from descriptiveness to suggestiveness, so the mark is a little bit more distinctive. So I know that's kind of a lot in answer to your question, but I think those are all things that people need to be thinking about.
No, I think that's really helpful. So, a couple things I'm thinking when people want to choose a name, they should be doing a Google search. They should be talking to a lawyer. If they're spending the time and money on a name that they plan to brand, or even if they don't want to get a trademark, but they think they've chosen something distinct, it is worthwhile to have somebody checking to see if anybody else is trying to register a name that's similar so they can object to that as well, right?
Yeah, absolutely. So at the federal level, the trademark process is a little bit more lengthy. It's very transparent, and there's every trademark application goes through a substantive review. As part of that process, anybody may oppose the registration of a pending trademark if they feel that they could be harmed by that registration. So that's your hypothetical is a perfect example. Maybe I've been out using a particular name and maybe it's not super distinctive and I haven't thought, oh, okay, you know, I need to register this. It just hasn't been worth it to me. And then somebody else comes along and they want to register that name, or they want to register something very similar to that. I would have the right, as long as I am sort of monitoring the Federal Trademark Office, and I filed within the very narrow window of opportunity, I would have the right to oppose that registration. And not because I have, my own registration, which is always grounds to oppose a registration. But, if I feel that once they get their trademark, they might then come after me and say, hey, you can't use your name because we've got a federal registered trademark. At the end of the day, my lawyer is going to tell me, hey, you'll prevail, but I'm going to spend a lot of money to prove that point, right? This is another way to sort of just like nip that in the bud, right? Just if you're monitoring and you see somebody out there is likely to get a trademark and you think that that could maybe be used against you or somehow, diminish your own trademark rights, you have the right to oppose that. Now, that's only at the federal level, that sort of opposition process. At the state level, if you saw a state registered trademark that you objected to, you'd have to sue to have it canceled. You'd have to go to court for that. There's no similar application process for state trademarks.
Is it worth it to get a state trademark?
It can be. I think there's no downside to it. It tends to be very inexpensive. It's a great way to establish use, in intrastate use of your trademark. Under most state statutes, it'll give you a couple extra causes of action if you ever needed to go to court to enforce your trademark. Not only would you be able to have the basic unfair competition laws, but you might be able to claim, infringement of a state registered trademark, which adds additional remedies like costs and attorney's fees and other types of damages. So it becomes an enforcement tool, I guess, is the best way to look at it. If you have an Illinois trademark and somebody's doing business in California, you're not going to be able to take your Illinois trademark to California and say, hey, I've got an Illinois trademark. They're going to be like, so what? This is California. But if you had a federal trademark, you could take that to any state, any federal territory. And in fact, you'd even be able to take it to foreign jurisdictions if you, followed the international filing process.
Okay, that's good to know. And then I guess one last thing I just want to point out is that, a lot of time people are picking up not just the original name of their entity, but a trade name, sometimes multiple trade names. And the same rules would generally apply to trade names that you're using. And the one thing I kind of want to mention is a lot of practices want to sell down the road. They build a business and they're thinking of selling. And part of what they're selling is also their goodwill, their identity, their name. And so having a trademark, having a name that they've protected, that nobody's going to challenge is very valuable. So I also think people, need to really be thinking down the road. And also just in terms of expense, the last thing you want to spend time and money branding and then have to throw that out and start all over again. So there's a lot of business considerations when it comes to name use.
Yeah, absolutely. You should really be thinking about it. You should be working with a trademark from the very beginning because it might seem sometimes expensive on the front end to spend this money, but it's really an investment that will certainly pay off in the long term. And investing it now and securing your rights early is far less expensive than, having to prove them in court or having to lock them down at a later time. So, it's always a situation where it's never too early to think about your trademarks and how you protect them.
Okay, great. All right. Any final thoughts on this topic? I think this is really helpful. I mean, it's helpful to me. I hope it's helpful to everybody listening.
Yeah, I think just really be proactive. That's the best advice I can give. Always think about what do you have, how can you protect it, what are you using, what are your long-term plans? Thinking about selling the business, thinking about growing the business, thinking about your names and your trademarks should always be part of that.
Great. All right. Well, thanks everyone for joining us on the Health Law Hotspot. If you have questions, you can follow up with David at adler-law.com, and we'll share his info when we post this. As always, if you want to catch our other podcasts, you can go to ralaw.com. I'm Ericka Adler, a shareholder at Retzel and Andress and leader of our healthcare practice. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.